guys, here we are. Thanks so much for joining me for this. We're going to just go ahead and try to get connected with this stream as soon as it comes up. I don't know about you guys, but when I tried to watch these things on Judge's stream, it's sometimes a little bit difficult to get to them when they start. They don't seem to set it up ahead of time. They don't store anything. So I might have to refresh a few times just to make sure that we get the stream. But going to do what I can for you here. So we're on a variety of competing motions here that are dealing with this survey that the defense is doing of prospective jurors in Latah County. And so basically what happened is on Friday, March the 22nd, this emergency order got entered to basically put the brakes on this effort that the defense was making parte without notice because, of course, the defense hasn't had an opportunity to be heard on that. So the original motion was sealed. The state has since asked for it to be unsealed, but we don't know exactly what that motion says yet. We just know that in general, the state's position is that this survey is violating the non-dissemination order that was entered back in June of last year, which was like the third variation of the order or something like that after it had gone through litigation and so forth. So the state's basically saying you're contacting these people that could potentially be jurors. That's the whole point, because you're trying to find out what they know about the case and whether they prejudged it or not. But as a consequence of that, you're feeding them information about what likely evidence is going to be and stuff like that. And that's in violation of the non-dissemination order. Well, the defense has come back pretty aggressively. They're really not happy with this process that the state has followed here. You know, what with the doing this without any kind of notice and getting the order to halt it without any opportunity to be heard ahead of time. And their position, looks like here we go.
We're in the courtroom, and
so
my understanding is
I'm going to go ahead and share
Nye
this now.
Is remote, and Ms. Beatty?
She's not with us today. She's tied up with some other obligations, Boise, Your Honor.
Okay, great. Thank you. Okay, so we have several issues to address today. And so maybe we should just start with the state's motion for order prohibiting contact with prospective jurors absent leave of court. Mr. Thompson?
Thank you, Your Honor. And to start, I want to help frame what the issue really is today. We are not here to debate whether the defense contracting for public surveys on public sentiment and that sort of thing is or isn't appropriate. That's not the issue at all.
I agree.
Our sole concern today is the nature of certain questions that have been propounded to residents of Latah County by a survey company that's contracted by the defense.
So in other words,
and we are
to decide what questions get
concerned with how those questions line up in light of this court's very clear non-dissemination order. I think the best place to start is to go to the court's June 23rd of 2023 non-dissemination order. And in paragraph enumerated number 1, starting at the bottom of page 1, the court ordered that counsel for all the parties and any of our agents and other attorneys are prohibited from making extrajudicial statements, written or oral, that the lawyer or agent knows or reasonably should know will have a substantial likelihood of materially prejudicing or otherwise influencing the outcome of the case. And that's essentially the language out of Idaho Professional Conduct Rule 346. But what is particularly important today is the next sentence. Your Honor directed, this order specifically prohibits any out-of-court statement which a reasonable person would expect to be disseminated by means of public communication, it relates to the following. And among the items listed are the identity or nature of evidence expected to be presented at trial or in the sentencing phase. Any information a lawyer knows or reasonably should know is likely to be inadmissible at trial, and that would, if disclosed, create a substantial risk of prejudicing impartial trial. And it goes further down to say this includes performance or results of examinations or tests. Our concern here is that the questions that are being propounded on behalf of the defense, and let me stop for just a moment. I want to be clear on this. We met with Ms. Taylor last week. Week before last, the 21st.
Thursday.
Yeah.
Before the Friday.
Thursday before the Friday when we filed our motion. Yeah.
Yes.
And we raised our concerns with Ms. Taylor. She confirmed for us that the survey was being conducted on behalf of the defense. And we raised with her the concerns we had about the specific language of the questions that were being asked. And Ms. Taylor represented to us, and I do not dispute this, that's why I want to make this part of the record, that she had not seen the actual questions themselves, that she had approved the topics that could be looked into during the survey. So I want to put that in the record that we are not accusing Ms. Taylor of drafting these questions verbatim and then say, go send these out to the public. We are concerned, though, that the people hired by the defense to conduct this survey did exactly that. And the examples of the things that are of concern can be found in the transcript of one of the calls. As Your Honor will recall, we had a person come to us who had received one of these calls, had actually recorded the call. And so our office prepared a transcript, and that was attached as Exhibit B, I believe, to our motion for order prohibiting contact. In addition to generic questions about the criminal justice system, here's where we get to things that concern the state immensely. Question: have you read, seen, or heard if Brian Kohberger was arrested at his parents' home in Pennsylvania? Question: have you read, seen, or heard if police found a knife sheath on the bed next to one of the victims? Question: have you read, seen, or heard that DNA found on the knife sheath was later matched to Brian Kohberger? Question: have you read, seen, or heard if Brian Kohberger owned the same type of car recorded on video driving in the neighborhood where the killings occurred? Have you seen, read, seen, or heard if the cell phone tower data showed that Brian Kohberger made several trips near the victim's home in the month before the killing? Have you read, seen, or heard if the university students in Moscow and their parents lived in fear until Brian Kohberger was arrested for the murders? Have you read, seen, or heard if Brian Kohberger said that he was out driving alone on the night of the murders? Have you read, seen, or heard if Brian Kohberger stalked one of the victims? Have you read, seen, or heard if Brian Kohberger had followed one of the victims on social media? Your Honor, there is absolutely no question but that those questions are disseminating by means of communication evidence expected to be presented, evidence that could be or would be inadmissible at trial. And I will say there are a number of these representations placed in the form of a question, but representations of fact that are not true or that would not be offered at trial, or the performance results of examination tests. And these questions specifically refer to DNA testing. Now, I recognize that the defense says, well, all of this information is out there in the public media somewhere, but that misses the point. That's assuming that every person in Latah County who is called has followed all of this nonsense in social media, has followed extensive coverage. There are people who consciously avoid reading coverage or listening to coverage about this case because they don't want to. That's the fallacy of the position defense is taking here. So what the agents of the defense have done is they have gone out and interrogated 400 citizens of Latah County and embedded in them facts specific to this case, some of which are not even true, some of which would not be admissible in court. And those people, whether they had heard that information before or not, are now saturated with that information. That is exactly what the non-dissemination order was intended to prohibit. That is reckless conduct, and it's outrageous.
Reckless and outrageous.
They could ask a survey,
He
and they
sounds
could
like
ask people,
Jackie
what do you know
Childs
about
there.
the Brian Kohberger case? What have you heard about the Brian Kohberger case? What do you think about the Brian Kohberger case? Do you have an opinion as to whether he's guilty or not guilty? Why do you think that? They could ask all those questions, legitimate survey questions, if you wanted to do a legitimate survey of public sentiment. But these questions go far beyond that. And I recognize that that it is represented that the survey questioning here in Latah County with those 400 residents has been completed, but they're already saying they want to take these questions out to other possible veneers. Doing the same thing in other potential jury pools that they're doing with our own. That is far beyond acceptable. These are questions that, quite frankly, might not be able to ask in voir dire, much less into an uncontrolled, unsupervised environment without any bounds, and just recklessly feeding this information, which is sensitive. And it's particularly sensitive when it comes to information that the state does not believe is true, or the state does not believe would be admissible or would be offered at trial. On the issue of whether information already publicly available isn't included in your honor's order, which it clearly is because it doesn't say otherwise. We know
It does say
that there's no
otherwise.
exception in the court's order saying if the information is already publicly known, it's okay to disseminate it again.
To be,
And indeed,
Bill.
that would be reckless for
To
the very
be
reasons that I
of
just
the order.
articulated, Judge. We would then be feeding information that is potentially prejudicial or that could affect the open-mindedness of prospective jurors to people who may not have heard it before. That's completely reckless. And so, Your Honor, based on that, we think this needs to come to a stop. We think if the defense wants to continue doing survey work, which they are welcome to do, given what we've seen here, that the questions need to be approved by the court before they go out. And the question certainly should not include the types of questions, fact-specific questions that have been delivered to 400 citizens of Latah County. That's where we're standing right now, Judge.
Section
Thank
2V of the revised
Thank you. So,
amended non-dissemination order.
then how can you compare unless you use the same questions? That's the problem. I mean, the damage has been done.
Well, that's one argument to make, but we don't want to perpetuate the damage that was done. And if they want to do a comparison, then they could have another survey in Latah County and do a responsible survey questionnaire instead of one tainting this people. And frankly, they should ensure that they don't go to the same phone numbers that they preloaded with this other factual information when they make their legitimate survey inquiries. The defense's people brought this on themselves. It's not the state's fault. Nobody had control over this other than the folks working for the defense. They made their bed.
The expert.
They got to live with it.
Let's hear from him.
I mean, frankly, if we were in the commercial context, we would say, not only will you do this over and do it correctly, but we will not pay you for the work you did that was so outrageously wrong.
There
That's
we
not
get
the
to the nut
context
of
right
it.
here. I don't care about that. What I care about is making sure that more people aren't tainted. And I would suspect, Judge, as we move forward in this case, that the state will be asking the defense, and if they aren't willing to provide it, asking the court to order the defense to provide the identity of every person that was contacted in those surveys. So when we get to voir dire, we can identify people who have been contacted, I guess is the best word to describe, and faced with these questions. And so we can incorporate that into the questions during voir dire to see just how much impact, if any, it had on each one of those particular jurors. I don't know how else to deal with this. I realize.
Disqualified 40 people.
Well, we could 400.
400, that's what I meant, sorry. Yeah,
400. And we could do that. You know, Lake Tahoe County has almost 40,000 residents, although not all of those are going to be part of the jury panels, prospective jury panels, but 400 may be a reasonably small number. And yes, I think that certainly would be a viable solution, is just identify those people. We can certainly identify them by telephone number it was called, and just not include them on the list.
Since you're standing up, you want to talk about due process?
Actually,
Yeah.
Mr. Nye is the one prepared to talk about due process, and that's why he's on. He's available by Zoom. If you'd like to have that now, that would be good.
I'll come back to that.
Yes, sir. Thank you.
I'm concerned about that,
Good.
Ms. Taylor. So go ahead, your turn.
Your Honor, we have Brian Edelman ready to testify by Zoom about these surveys if the court would hear his testimony.
First, I want to hear about the process. I care more about how this came down than what he did. Although I just learned for the first time that you had nothing to do with the questions.
I didn't write the questions, Judge. Those questions are generated by Brian Edelman, and he can tell you who he is and his educational background and why the questions are crafted as they're crafted. But I approved him doing this survey. This is not an anomaly. These kinds of surveys are done in high-profile cases quite often. I don't know how I could present to the court what's going to be required at the venue change hearing without understanding what is going on with the public. This is an anonymous survey. This is not one where anybody's identified as far as the defense wants to know this or the prosecutor wants to know this. It's a random survey, and there's a reason why there are general questions and more specific questions. And Mr. Edelman can explain that, but I'll do my best to paraphrase that.
Okay, well, I'm just curious. Did Mr. Edelman was he aware of the dissemination order?
I don't know if he was aware of that or not, but we gave him no information in the case, Your Honor. He received nothing from us as far as no police reports, no contact with our client, no interviews. He received no information. His entire construct of this survey is as he does in his high-profile cases. He pulled the media local to this area to see what the most common stories were. Those are things that are in the public arena. This court and counsel knows how much coverage this case has received. And he does what he does by looking only at what's in the public. We didn't provide him any police reports. We didn't.
I'm sorry. It's just that does miss the point. I mean, it's kind of ironic that we have worked so hard, including you, okay, both sides, to protect a fair trial. Okay, and our concern from the very beginning was all the media stuff floating around, okay, that affects your client, Mr. KOHBERGER, to get a fair trial. And some of these questions actually create a concern about, that they're inculpatory. It could be prejudice for his client. Okay, and that I'm just surprised that both of you didn't come together and say, there are certain things that we probably shouldn't put into the public.
It's already in the public.
It really concerns me, and that's why I did what I did that Friday.
The order
Now I'm
says
being accused of violating a due process,
in
which
the
is a
public
whole
record.
big issue for me.
I can understand that would not be taken. I have to represent my client to the best of my ability. And the reason for that, Your Honor, with all due respect, I was shocked to see the court issue an order within hours of the state filing a motion late on a Friday without giving us a chance to be heard. And that's going to delve into our argument on due process. But since it came up and since that feels like the elephant in the room right now, I think maybe we should just go ahead and address that.
Sure.
Let's talk about
And that
the
was my,
stuff.
and I asked you to set aside the order that you made without having a chance to hear from us, making a decision that now you're locked into, and it was a one-sided
I'm not locked into
decision.
anything. My order didn't say it was permanent,
Maybe
and
I,
it told you that I was gonna have a hearing.
maybe I phrased that very poorly. It's a decision that you already made.
Okay, let's go back. I got the motion at 4:30 on Friday. Now, it doesn't even reflect, just when it was filed, because Odyssey has a delay, right? So I get the motion at 4:30 Friday. I get a response from you at 4:45 Friday, right?
I don't know what time you received it, but I
That-
filed an
that's when I
objection the
got it.
minute I could.
Because then you know that about 5 o'clock, that's what I issued that. So I had a half an hour. I read the materials
That's on you,
that
Judge.
were attached to the motion that the state filed. And I had very little information. But it seemed like there were some real legitimate concerns about the survey. And obviously, it turns out there are concerns, legitimate concerns about what was done in the survey. So in my order, I told you that I was going to set a hearing. So I don't know what your understanding is with just the process. Okay, but I, on Friday, sent this hearing. So what are we doing today? Okay, I'm hearing you out. You had notice. I mean, really, that's what we're talking about. That's what the law.
No,
What
We're
is
talking
your
about your ex
understanding
parte order,
of
Judge.
due process?
My understanding is that I should have notice and an opportunity to be heard.
And you did that.
I'm having that now, but there has been a decision made by this court almost 2 weeks ago that stopped us from completing our work. I understand that Mr. Thompson raised a concern, and his last paragraph to the court in his motion was, it seems that it may have violated the non-dissemination order. And so we're stopped from completing our comparative surveys right there when we're up against the deadline to get to our motion to change of venue. I'm looking at, it stops me from doing the work and meeting the deadlines to argue for Brian to be in a place where he can have a fair trial. I think the court should not have issued an order stopping us, but set a hearing, shorten time, set it for Monday morning. If the court wanted to set a hearing for that Monday morning, we wouldn't have lost 2 weeks worth of work if the court chooses to let us complete the work.
But that could have been more damage. I mean,
How?
this less than 2 weeks really has very, very little impact, okay, on your work.
Okay, that's
It does have an
great
impact,
submission.
Your Honor.
You don't even have a trial set.
We
I mean,
have-
come on.
We have our motion to change venue. We don't have trial. You're right. We don't have trial. My understanding was that we were going to hear the venue change and the court was going to make a decision and then set trial, so that we didn't send out a bunch of subpoenas and reserve this courtroom unless we're going to stay here. That was my understanding. My problem, what sets me back, is getting my work complete to get my briefing to the state in the time and the deadline that I was already given, and meeting that hearing date that's set for venue change. And from there, everything else flows. When are we going to set trial?
We wouldn't even be here Okay, if there was some communication between you and the
It's
state
none of the state's business,
about the
Judge.
survey.
The state isn't in charge of the questions.
There are things I can communicate with the state about, and there are things that I cannot communicate with the state about. How I'm preparing my case is not one of those things. It's just not one of those things. I go and see Bill and Ashley. I go to their office every week. Oftentimes we talk, we email each other, we talk to each other. But I don't need their permission every step of the way to prepare my case.
That's right.
Doing these surveys is not an anomaly. This is something that's done in these high-profile cases.
Well, apparently, Mr. Edelman did not even see the non-dissemination order,
Because
and you
that
apparently did
doesn't
not give
include
that to him.
information.
So this is a very not a usual case, number one. And you know that we've been working very, very hard to keep the sort of noise out of the case. And now it's been injected, at least to these 400 people, without a permission of the court, without discussion with the state. I mean, that's troubles me. And then when I'm being accused, directly accused, okay, by you in your brief, that I violated his due process rights.
You signed
Now,
an ex
that's
parte
not what the
order,
law
Judge.
says, and that's not what the facts are. And you even cited cases that say exactly what due process is in the law, right?
I understand that, and I agree that's what due process is. My issue is that the order was signed, stopping our work without a chance to be heard. It's as if the state and the court had decided we violated the non-dissemination order, and we didn't.
All I was doing was stalling it, okay, for less than 2 weeks so we could have this hearing, number one. Now, if you feel like you've been prejudiced or your client has been prejudiced for less than 2 weeks, okay, in this work, I'll push it out. I'll just push out the trial. I mean, not the trial, but the hearing. I mean, is that satisfactory?
Your Honor, I think that might be what we need.
Fine.
I need to figure out if we're going to be able to continue the surveys. But if we are, I expect that we will need some additional time to get them done so that I can get the work to the state to review.
Okay, well, that's a different issue. I've never said, no, you can't do a survey. This was a total shock to me that Friday at 4:30.
I can understand that. It
I
was
had
a
to-
shock to the
I had to
That's
state.
why
stall
the
it
state
out,
presented it
okay?
that way.
Because so that we could all talk about it and figure out what is the right path. Okay, because this is a big deal and I take it very, very seriously. And I was surprised, okay, that this was happening behind our backs, my backs. Okay,
Defense
I
preparation.
understand that this probably is the first time
happens
this court
behind
has
your
run into it.
back.
I know it was the first time that Mr. Thompson has run into it. I haven't used the survey in my own cases because I haven't had a case like Brian's case before. This is an extremely high profile case. I've been involved in a lot of capital cases and I understand the standard of care in capital cases. I also know that this very kind of survey was used about 7 years ago in Kootenai County in another high profile case. I wasn't on the case, but I'm aware of it. I'm aware that this very survey has been used in other jurisdictions, other counties in Idaho and other states in really high profile cases. So I understand that it was a surprise to Mr. Thompson. He told me it was. And I'm hearing the court say that's a surprise as well.
it's how it was done. I'm not concerned. I figured there was going to be a survey at some point. There would have to be. It was the way it was done, okay, and the questions that were asked. That is the real problem, as Mr. Thompson pointed out.
So the way it was done,
The expert then.
I know in the other Kootenai County case, permission to do the survey wasn't sought of the state, the prosecutor, or the judge. I can comment on that one. I know about that. I don't know about the other cases. So that takes us to why did we ask the questions we asked? I don't think it's common to get permission from the state to do our work.
Yeah, that's
I
right.
think that it's a surprise because it's the first time that's happened, at least when this court's been on the bench and in Mr. Thompson's tenure here. So I understand that. When I met with Bill and Ashley in their office on the 21st, I asked them not to give you the police reports that they had in the transcript without me having a chance to be heard, because I didn't want an order without us being able to talk to the court. I asked if we could maybe set up an on-the-record meeting with the court to talk about this. And that wasn't what was done. It was Friday when this went out.
Sure. I mean, I would have been available on Friday to talk about it if that was necessary.
I would have gladly
Why didn't you?
sat down. I
Let the
didn't offer that
prosecutor
next
drive the
Friday. I would have
process.
come to town for it. I offered the following Thursday and Friday, knowing that I had a lot of availability both of those days. I would have come to town. I would have gladly sat down. By this point, the prosecutor knows I'm not telling him my preparation in the case, and I could have explained it. The thing I didn't want to happen is exactly what did happen. All of a sudden, there's an accusation against us and there's an order signed stopping us. I appreciate the court being willing to just push everything out 2 weeks. I think that's helpful. And I mean, if that's what the court's willing to do, that's fine. But the problem is we are stopped and then we have to respond to this. And if you think about the non-dissemination order, for sure, we wanted that non-dissemination order. We're the ones that asked for it. We're the ones that argued for it. We also know that our non-dissemination order mimics Idaho Rule of Professional Conduct 3.6. And when you look at that in the comments of that, I think it's helpful. There are things that we can say publicly, but we choose not to. Our team doesn't even so much as answer no comment to emails, to calls, to people trying to talk to us, because we just don't want to do that. It's easier to say nothing. So the construct of this survey is to ask these general questions. And then you ask specific ones because you get different answers when you ask those. It is not injecting information. They are, have you read, seen, or heard? And remember, these are anonymous and these are random. So they're not planned. Nobody's planned to be contacted. I don't know the names. I'm sure I can get the phone numbers if that's what the court wants. But I don't know who the people are. Nobody's identified as the person they're being called on behalf of, even when pressed by Detective Payne, that people conducting the survey didn't know. If we go back to the non-dissemination order, which mirrors Rule 3.6, that's to prevent lawyers involved in a case from making statements that will be widely disseminated, right? To talk to the press. And the purpose of that is because I read the police reports. I would have a little more credibility than anybody else on the street saying something about the case. Same with Bill. That's the purpose of it, so that we don't say things to the press on Dateline, on 48 hours, because we've actually read police reports, we've interviewed people, and we're doing the work on the case. So when you have an anonymous survey that doesn't identify the person conducting the survey, didn't know who was behind it as far as which party to the case, they can't answer that. So all of a sudden, their questioning about what you've seen in the media doesn't come from a particular party in the case. And the purpose of it is to ferret out what if people have exposure to the case. If you look at State's Attachment B, you can see on page 2 that there's questions, and I'm at lines 10 through 12, about what they know about the case from the media. This is all, again, looking at our non-dissemination order and looking at the rule, things that are in the public record, right? That everything is public in this case unless we specifically seal it. So this person says they don't know much. And then if you go to page 4, there are several things they do know. And that's the purpose of it. When somebody's given a broad question, tell me what you know about this. They're like, I don't know. I don't really know what you want, so I'm not going to say anything. And they don't give you an answer. But when you say, have you read, seen, or heard X? Well, yeah. And then it's the next question. And if the answer is, No, I don't. It's next question. Nobody's saying, well, it was in the newspaper on 15 occasions. And this is particularly borne out when you think about the things, and the state said it, some of these things are things that are just not true. That's what the Haddon case tells me I have to show you. It's not enough that there's just a lot of media coverage, and it's a lot more harmful if it's media coverage about things that aren't true. So it's nobody's injecting anything into the case. A random small percentage of the population is contacted. Have you read, seen, or heard things that are lifted straight out of the media? And if the answer is yes, you move on. If the answer is no, you move on. That's what the survey was about. And you can see why, looking at pages 2 and 4 of State's Exhibit B. And I think that we should also think about what the words in the non-dissemination order mean.
Mm-hmm.
When you say we disseminated information, that means to make widely available. This is a one-on-one conversation with no party identified. This isn't making it widely available. When you talk about disseminating information, the definition of that is to put it out there by public means, radio, TV, social media. And that's not what was happening either. These were questions. And they were things lifted 100% from the media, 100% already in the public record. And it is a one-by-one conversation. This isn't something that's being put out there through social.
Well, it kind of is.
Well, now it is,
Judge,
but I certainly didn't expect
400
this.
people, okay? It's planting some seeds where then people are encouraged, or they think, oh, wow, I didn't know that. I'm going to look more into this. I mean, again, we were trying to keep the false information that was out there in media land, that it wasn't going to affect your client.
I agree. This is less than 1% of the population. It's one-on-one. It's not by means of public communication. To think about alleging that we violated the non-dissemination order is basically alleging that we violated our ethical rules as well. And there's parts to it.
I'm not accusing you of that, especially now that I know that you that you didn't.
I didn't write the questions, but I knew what was going to happen. I mean,
yeah, Judge, stick to your.
I take responsibility for the choices on the case, Judge, but I just don't think this is a violation of the ethical rules or non-dissemination order. These are questions about things already in the public record. That's in our order. That's in the rule.
Order. Thank you, Ian.
Let me ask you this. I mean, really, getting hit by this on late on Friday afternoon, okay? I mean, I'm not sure what a judge should do in a situation like that.
Why don't you hold
I
the
just
state
say, yeah, no, keep
for
going
making it your
until we can
problem?
have a hearing in 2 weeks or less than 2 weeks? Or do you just pause it down so that everybody can talk about it and figure out if there is an issue? That's how I looked at it from where I was sitting and what the information that was provided to me. And you did respond it, but you said you were going to submit a brief and affidavit. That's great, but it was 5 o'clock on Friday.
I know.
So,
and I mean, I can't tell you how frustrating that was for me. I'd had this conversation with the prosecutor the day before. I'd offered to come and talk to the court and let the court look at all this. I knew full well if they did exactly what they did, the court would sign an order before I had a chance to say, hey, wait a minute. Let's really look at all of the words in the non-dissemination order. Let me tell you why we did this. I knew exactly what would happen. I don't want to say that there's that you should do something different. I want to be heard on these things. I don't want the court to, on a Friday night, get a flurry of things that I can't respond to and ask you to think about the bigger context. we're lawyers, words mean something.
Well, did
Also,
you think I wasn't gonna give you an opportunity to be
You
heard?
didn't.
No, your order said I could be heard later, but there was a decision that was made then. And it's hard for me to wrap my head around the court taking this as an emergency motion when the words in the state's motion telling you put a stop to it are, it seems like they might have violated this. That is a weak accusation for the court to take an emergency order position on. But I know why the court did. The court has all of this and no context for it. And it's a Friday night. And I mean, if you'd received this on Thursday, my guess is you would have said, we're having a hearing Friday morning. I don't care if it's by Zoom.
I told you all, both sides, you know, if you need to have a quick hearing, let me know. We can do it on Zoom.
Why are
I mean,
you
I
blaming the
want to
state,
move this
Judge?
thing along.
I
And
would have
now
been
we're spending
available.
all this energy, okay,
Yeah,
about this issue.
She didn't
I
bring it
lost
to
a
you.
weekend of
Friday
what I
afternoon.
planned to respond to this. I thought we would probably be dealing with it on an in chambers on the record meeting on the Thursday or Friday until I got the motion.
Yeah, I have about 7 briefs in now.
Well, you can see we lost a lot of time.
I'm not complaining about it because I'm learning a lot.
The last thing I'm gonna say on this, Judge, is that non-dissemination order contemplates that you make this statement that you reasonably know is gonna go out and harm the trial. This survey was never intended to do anything but identify issues within this county to support or defeat our argument for venue change. When you hear from Brian Edelman, which I don't know if you have to now because I've said most of the things.
I'm happy to hear what he has to
We
say.
want to hear
if
from him.
you
Make
want
the
to
record, Ann. Make the
be
record.
said
Make the record.
to me.
You would know, and you probably know from his affidavit, sometimes he recommends against venue change.
Sure.
Because it's not there. He's done with Latah County. The results aren't compiled yet. I anticipate he'll recommend we change venue. Where we are now is we'd like to finish the other 2 counties. You don't have to do 2.
Well, you did say that he said that Latah County is biased.
I anticipate he's going to recommend we change venue for that reason.
I'm interested from him how he defines bias.
And
We all have some biases.
I will not put words in his mouth for that one.
I'm not expecting you to do that.
I will either have him testify today if you want to hear it today, or we'll do it at the venue change hearing when we get there. The question, I understand the court's willing to set our deadlines out 2 more weeks for venue issues. The question remains then, what do I need to show you? What do I need to present to you so that we can do a survey, a comparative survey? The target is 2 additional counties, and I really hate that I'm in here telling you all what we need to do, but here we are. So what we need to do is survey 2 additional counties. And I mean, we don't have to, we can come in with what we have, but generally I think courts ask, where could we go? And I think that's a fair question here, because we do know the media coverage has been extensive. And so I think it's fair to understand if there's a difference. If there's not, then you're left with
Are you going to tell me what counties?
I mean, I can. Do you want me to publicly disseminate that? Because this is the very definition of public dissemination.
I don't know if that should be done, or it seems like it could have some whether or not there's some credibility about the survey, depending on what county you are looking at. We have very different counties and different thinking throughout the state. So I don't know what Mr. Edelman has in mind, or what you have in mind.
I can tell you, Your Honor, his recommendation is that we do one of the counties in Southeast Idaho because it's a different news feed and it's not on the front page of the paper every day. So we will do a Southeastern Idaho county That would either be Bannock or Bonneville, and I think Bonneville is slightly bigger than Bannock. The other county is Ada, and the reason for Ada is because it has a very large courthouse with a lot of good security, and that court system has handled high-profile cases in a way that's safe for everybody. The population's very large there, so even if we had to draw off a lot of jurors, would have the population there to do it. Additionally, Ada County makes sense when you look at the Rule 21B, the convenience because of the airport and the number of out-of-town people that will be coming in, and the ability to have hotels and restaurants where there would be people wouldn't be running to other people necessarily. So Ada makes a lot of sense for a lot of reasons to me. Those reasons, the courthouse security and places to stay among them. But Mr. Edelman, Dr. Edelman has told us that because of the news feed that we really need to do a Southeastern Idaho. And so the decision was to do both. And in my mind, that is because it makes sense to know if we're going to go to the time to understand this and really give the court a picture, the court might want to know those two questions.
Thank you.
Yeah, you need to know if 8 is just as biased.
I don't think I have anything left to say right now.
Okay, thank you. All right, Mr. Thompson or Mr. Nye?
I'm not sure that the due process issue is something that's at issue right now.
I think I've already made it. This decision, I mean, based on the facts and the law, I mean.
Absolutely. There's no due process
We
violation.
know you're going to
here.
say you
There
didn't
is
violate his
nothing
due
wrong. In
process,
fact,
Judge.
law
You already know.
contemplates the court can take emergency action to stop something and call a timeout until it affords everybody the opportunity to have their say and the court can make the final decision. That is all Your Honor did here. And I would suggest, Judge, that it would not be prudent or proper for Your Honor to change or limit your own authority on that. I think that you have to continue to reserve to yourself the ability to act quickly, to cause a timeout if you are alarmed sufficiently to justify that, and to give the parties an opportunity to appear before you and sort it out. Before.
I'm not going to change that, that's for sure, because the law allows me to do that.
Yes, sir.
And I know what due process means.
And I say that only in light of emails that your staff attorney sent to us the other day ago, suggested that maybe the court was not going to be entering orders without full hearings with everybody.
Oh, well, but Ms. Taylor wanted, she said, from here on out, we're going to talk about that too. Because now I understand, because I haven't seen it yet, because I didn't have a computer, that you are stipulating to sealing all of the discovery stuff, and I just stopped, okay, in terms of signing on those orders that you're sending me, because I don't want to be accused of doing the wrong thing. And there's another situation.
Don't be such a victim,
Ms. Taylor, about that there was a prior thing where I had done that about the IPD.
Yeah.
And the state asked to do a public order, just to say that we provided the IDG or some of the IDG to you. And that doesn't really say anything except that. But you were criticizing me for that too.
Your Honor, to be clear, it's not the content of that order. My concern is the process. My concern is it feels like from our perspective that Mr. Thompson says, hey, Judge, can you do this? And I'm getting ready to weigh in and it gets done.
I didn't get a response from you.
Your Honor, that was out the same day. I was in the process of writing, and this was by letter, it wasn't by motion. I was in the process of writing a letter to the court asking to be heard on some issues, and the order was signed, or the new order was generated. The content of it isn't the problem, it's the concern about the process, the concern about making sure we have a clear record of what's done, and the concern about things halting what we're doing before we can be heard. And
Okay, but did you want that to be not sealed?
No.
The other part, all the IGB stuff, that's like 6 pages, 7 pages?
No, Your Honor, I don't have a problem with what the court ended up doing. I was concerned about the process. And then having this order issue on a Friday without having an opportunity to talk about it, my alarm bells go off, and I think this can't happen. I probably have the court's attention squarely on me in this issue, which I anticipated, but what I didn't
both of you.
want to have is I don't want to have the prosecutor writing the court letters and the court doing something and me running around trying to catch up. I mean, the thing that happened is fine, but then we have this other thing that happened, and I don't want this habit. I understand.
Survey.
I understand. I'm sorry.
The survey, that's what.
Yeah, the order to stop. Yeah.
Sure.
So it's that there are two things that have happened without me being able to even weigh in, that's done when the prosecutor asks you to do something. And I don't like that. I want to have opportunities to be heard. I certainly understand a court's emergency power, but if this was an emergency, the state knew from March 8th about these surveys. The state sat down and talked to me, and I offered to see you with the state. And then their motion said, it seems like it might be a violation. So I think maybe we need to define emergency a little bit better, because I know you have those powers and I wouldn't ask you to not use the powers that you have. I think the problem here is the way this gets presented when there were a lot of different roads and it cuts us off. And that's what I don't want to have.
Okay, I want to solve this problem if it's possible. One of the things, I mean, because you have filed motions where you didn't ask for a hearing. There's still one, couple hanging out there. Okay. And so I don't know if I'm waiting, okay, if you're asking for a hearing or not.
Yeah, Judge.
Or if because
Oh, my
historically you
This is a
guys
little
have
concerning.
worked really well together. Okay. Stipulations, but then I don't get a stipulation. I don't get a request for a hearing. So what am I supposed to do then? So what I'm starting to wonder about is maybe we should just have a hearing, okay, at least once a week. I mean, a month, maybe once a
I'm
week.
here every week.
Maybe
You can
once
do
a
it.
week. Okay.
You can do it.
Like a Thursday afternoon,
That's
okay,
the day I'm here.
and then, okay, so and
Status hearing every
then
week?
we can kind of clean out a lot of these things that are sealed, or arguments about this or that. I don't particularly want to do that, but you and the court, okay, both of you, I say you, both sides, that you worked really hard, okay, to protect the goal of a fair trial. And all of a sudden I feel like it's cracking a little bit with the work together, okay?
Well, no
Because
shit. It's a death
if we have
penalty
to
case,
have
Judge.
hearings on every single thing, we got a long ways to go. And it's a lot of time, it's a lot of work, it's a lot of money. And it just makes everything more difficult. So if you can come together on certain things, then it's a stipulation that we need, then it's a stipulation. If it's a hearing, it needs a hearing. I'm fine with accommodating whatever needs to happen in short notice too. Because, like I said before, I just want to keep moving on this. Just so taking a long time.
Your Honor, I think the record shows that we have been able to stipulate probably to the majority of things. I don't keep count. There are some issues that we have not been able to reach an agreement on. And bringing it back to the issues that are before the court right now, I realize we have a bigger picture to talk about. But the defense makes a big deal about the state hearing that there were surveys going on in our community back in around the 8th or so of March. And as The declaration that's been filed with the court shows, yes, we did. And we immediately referred that to law enforcement to investigate, find out what these surveys are about, find out who these people are that are doing the survey. If you can, get that information to us. And that process is in the works. And just days before we were able to meet with Ms. Taylor on the 21st of March, just days before, we got the reports from the police department, and we also got that recording. That, frankly, the recording is the icebreaker on this. It's the game changer because it's literally what was being said, what was being asked, what was being represented in the form of the question. Ms. Jennings called, reached out to Ms. Taylor, say, do you know anything about this survey? Ms. Taylor says, yes, I'll be in town on Thursday. How about we talk about it? Okay, so we sat and waited. I can tell you, I suspected that this was something that the defense had commissioned from the first we heard of it. But I didn't feel that we had enough information about the nature of the survey to determine whether it was problematic. And we've said this already, and it keeps getting missed in the arguments here. We don't care about surveys. We care about these particular questions asked in this particular survey. The defense is welcome to contract with people from California or wherever, I don't care, to go and ask people, can you be fair? What have you heard about this? All of those questions that
Here, it's such a
Ms. Taylor was just talking about at page 2 of the transcript. Those are appropriate questions for a survey. Page 4 are not appropriate questions for a survey. Just because they're put in the form of the question doesn't change the fact that they are an affirmative representation of a fact that if the hearer, the listener, was not aware of it, now they have been tainted by it. They have been, in your honor's words, they have been injected with that information. That is a clear violation of the non-dissemination order. To think there's a distinction between putting something out in a press release and talking to a private citizen is a distinction without substance. Those are both public contacts. And I can guarantee that if I went down to the bar and had a few drinks and was talking with some people and say, hey, did you know about this, about the KOHBERGER case, and the defense found out about it, they would go ballistic. And for good reason. That should never happen. But that's exactly what's happened here. Not by Ms. Taylor. I'm not faulting Ms. Taylor for the questions themselves, but by the people they hired to do this. And it had to stop. Your honor was absolutely correct. Cut it off. And let's sort this thing out. And if we lose 2 weeks, well, we can make up 2 weeks. Your decision was perfectly appropriate. For the defense to claim that there's some due process violation there is without any legal basis. The defense's objection is, we don't like it, Judge. Well, there's lots of things that happened in court that I haven't liked, not in this court.
Well, probably a few.
Well, maybe with your honor in other cases outside.
We'll come back to this question.
That happens. That's part of the game.
I'm not here to.
But just because somebody complains doesn't mean that it's legally wrong, and there is no due process violation here. And Mr. Knight is prepared to argue due process minutiae if that's what we want. But I don't think we need to deal with that. We are dealing with the issue of these questions in the survey. They are completely inappropriate. We have a group of at least 400 people in Lake Tahoe County who have been exposed to this in violation of the non-dissemination order. I think your honor is probably right. The only way we can deal with, or the best way to deal with that, would be to exclude them from any prospective jury pool. But we sure as heck don't want to say to the defense's consultants, yes, go do this in other venues as well, where if we can't pick a jury here in Lake Tahoe County, we may have to go to. Go ahead and mess with them too. That's ridiculous. I do not question the right of the defense to commission surveys, responsible, proper surveys, as part of the debate over venue. But this survey cannot stand. If they are going to do that, they need to start from scratch if they want to compare it to Lake Tahoe County. There is no way to take the 400 responses that have been loaded with these factual representations in the form of questions. There's no way that that can fairly be compared to surveys without those questions anywhere else. It's apples and oranges. And yes, it may be an expense and it may be a delay of time and it may be an inconvenience, but it is not of the state's making. It is entirely the responsibility and the fault of the agents of the defense. Entirely.
Where's
We don't
your
care if
expert
there's certain.
saying they've done it wrong?
Now, I'll keep saying that because we keep hearing from the defense that we don't do surveys in Latah County. That's not the issue. We know a survey is going to happen here.
I just don't
Now,
like
when
this
it comes
one.
to
Oh, my
this
Lord.
idea of what happened 2 weeks ago, when we met with Ms. Taylor, we said, Ms. Taylor, no, actually I said, Ann, we gave her the information. We talked about it. She indicated she wasn't aware of the actual questions. We said, we are very concerned about this. This needs to stop. And the response, if I remember, was along the lines of, well, we think they're about done in Latah County anyway. I said, well, we need to bring this to the court's attention. Here's my proposal. We will send a letter to Judge with these attached, copy to you, and then we can have a discussion. And I was told, no. The defense did not want, Your Honor, to see this without also having whatever they wanted to offer in response to it as well. I said, well, that's not how it works. I mean, we'll file a
Well,
motion.
how does it work? The defense has to
Normal
clear their
law
stuff with you? I don't
practice.
think so.
I've been practicing for 43 years. I lose count now. You know, if you can't resolve something, you file a motion with the court. If there are things you want to base your motion on, you attach them to the motion, and we proceed from there. And so that's where we left it. Ms. Taylor did say, well, I could be available the following Friday, Thursday or Friday, to talk with Judge. And to my mind, well, that's too little, too late. As far as we know, these surveys are going on again right now.
Well, you might have told her that.
Wrapping up or
Maybe too
starting
little,
somewhere
too
else,
late.
whatever.
Let's
It
do it
needed to be
tomorrow.
addressed quickly, not wait a week to have a conversation and then go into a conversation where you're left cold. We walk in the door and we aren't able to provide you the basis for our concerns. So you are completely helpless with information. That's not how it works. That's not how informed decisions are made. So we prepared a motion. We made the attachments. We filed it mid-afternoon, early mid-afternoon, not late in the day as it's characterized here. Now, I appreciate that Your Honor didn't see it till later in the day.
Right.
But that wasn't the intent. The intent was to get it filed as quickly as we could. There was no scheme to do some, 5 minutes to 5 o'clock filing and take some advantage of the defense. That's not the way we do business. That's not the way I do business. And frankly, it's a little offensive to have that suggestion made, but I'm going to move beyond that.
Oh my God. Oh no, he's offended.
I have to say, I am disappointed to learn today that Dr. Edelman and his associates were not made privy to the non-dissemination order. But we can't undo that. And once again, that's not of the state's making. My knowledge, everybody that has been asked to take actions of any type on behalf of the state has been made aware of those restrictions because they are our agents. And we know we are responsible under the court's order for the actions of our agents. Regardless, I'm disappointed.
So sad.
I also want to be clear
So sad this happened.
that I'm not standing here today making a bar association ethical complaint against any member of the defense team. Yes, language in the non-dissemination order contains language that parrots the Idaho rules of professional conduct, but the laundry list of things that the court lists, I think, are much more specific. And that's what we're concerned about. And if I'm wrong and those are in the comments, well, then maybe there's a violation of that rule, but that's not my interest. I have no interest in doing that. My interest is in taking care of this case, making sure that we can have a fair trial, making sure that Your Honor's non-dissemination order is honored, And at this point, trying to figure out a way to cure what has happened. The first thing to do is we have to say, Your Honor, the court needs to say, no, you will not ask any more questions of prospective jurors without the court approving it. Because we've seen that the people retained by the defense cannot be trusted in that regard.
Jesus.
Fools once, shame on us. Shame on you.
Over
Fools
the top,
twice,
shall we?
shame on us. We don't want to get into that. They wish to proceed with surveys, they can, but they need to start over.
Start over in Latah County.
Yes, sir. Absolutely. Absolutely. There's no other way to get a fair comparison with any other prospective veneer without doing
Why
the
don't
new
you just
survey in
do your
Latah
own
County
survey,
and not
Bill?
including
Do your
any of the
survey.
people who were surveyed in this 400-person group. That's the only way we can avoid this taint. Again, this is not of the state's making. We are trying to salvage a mess. As Your Honor noted, there's no difference between talking, and I said just a little bit of talking one-on-one and issuing a press release or standing down in Friendship Square with a bullhorn. The dissemination is dissemination to a member of the public, and it's equally in violation of the no contact order or the non-dissemination order.
Do you think some of those 400 people might have talked to other people, like their families?
I know
or their friends.
I know they have, Judge, and the reason I know that is we got a call from the sheriff's office earlier today where a woman called and said that she had heard about this survey and the survey made her uncomfortable. And when they called her back, it actually was her son that had received the survey inquiries a couple of weeks ago and happened to mention it to her. And she just wanted the sheriff's office to know about that. I mean, we have good, responsible people in this county, and they can sense what's right and what's wrong. You ought to be a trained lawyer to know that it's not right to go out asking these kind of questions to people who might be prospective jurors in the case. It's just not right. So that's what we need to do today, Judge. I don't believe there's a due process issue. Matter of fact, I know there's no legal due process issue here. I appreciate Ms. Taylor isn't happy with the things ready to roll out. That's life sometimes. But there's no due process issue here. And we ask that Your Honor enter the order, cutting off any more use of this survey, directing that that the defense, if they wish to continue with the survey, start over and submit questions to the court to make sure that we aren't getting ourselves back into a similar situation, baiting people who may have no knowledge of this case with detailed information, some of which is completely false.
We already
And not
did
only
that.
completely false, but it's false in a sense that makes Mr. Kohberger look bad. It is creating bias against Mr. Kohberger based on false or inadmissible evidence. That's outrageous. How can we possibly preserve a jury pool when that's going on? We can't.
How are we supposed to know
It has to
the effect
stop.
of this press if we
Thanks,
don't
Judge.
ask?
Mr. Thompson, okay, Ms. Taylor.
We need to hear from the expert.
So,
Come on, Ann. Come
not
on.
liking the result of a hearing or not liking an order from the court is one thing. That happens all the time. I think courts probably have people on both sides of the aisle that don't like whatever decision they make most of the time. And that's just the way it goes. What I complained about was not being able to have a voice before a decision was made. I think that's an important distinction. I'm not saying don't make a decision I don't like or I'll file a motion against you. I'm not saying that at all. I imagine over the course of this case, there will be decisions I like and decisions I don't. It's the way it's been in the past. This was solely about being shut out of the process before a decision was made. I understand the order said I could have my day. Here's my day. So that I want to make it clear. It's that motion didn't come because I didn't like the result. I didn't like the process. That was it.
That was my issue too. The process.
And I wanted to be heard about that. I do not think that these survey questions that related to what have you heard in the media injected information to people. I understand that this is a close community, and I understand that people will call officers with concerns and the prosecutor with concerns. And that's kind of the point. That's kind of the thing that I'm worried about, is the close-knit nature of it. That's a good thing unless you are an outsider having a trial, and then it's not a good thing. And that is kind of a problem that we have with that.
Well, I can tell you from my own experience, people I see, that there's plenty of people here who really don't like law enforcement that much. So I think it's always a mistake to stereotype people or communities.
Fair enough, Judge. Usually I don't find that people that have issues with law enforcement make their way to my juries, but
Yes,
that's
thank
probably
you,
something we'll talk
Ann.
about a different
thank
day.
you.
As
Demographics
far as
of the
where we
panel.
go from here, the moment of getting our work done and not having it out in public is over. So I suppose the court can weigh in on what we should do. I wouldn't be quick to say that we couldn't use the surveys that were done. I would, if that's the route the court is going to go to have us do other surveys. I mean, that's what we'll do if the court asks us to do that. But I'd ask the court to remember that it's quite common for the general questions to draw a no. And then you ask other questions, because then people are like, well, yeah, I did know that. And that's how you get to the heart of the real information. So I think there's got to be some give and take in there. I'll say two more things and then I'll be done.
No, give us the expert.
Our office did send Dr. Edelman a copy of the non-dissemination order. I didn't know he didn't receive it, but he didn't receive it. He definitely knows about it now. I would have caught that, but we didn't send him anything. Our process is to make sure that we have the signed order back from anybody that we're going to communicate with about the case. This solely had to do with him looking at what are the media stories, what are the big topics, so I can determine how saturated the community is and bias it. So that's why I didn't catch it. I'll take responsibility for that. But just to maybe allay some of Mr. Thompson's disappointment, it was sent. I don't know what happened, but he didn't receive it. He's sure this is my other thing is, if the court wants to change the survey, I would like an opportunity to speak with Dr. Edelman about the possibility of preserving what we've done versus just starting all over.
Oh, no, Ann, don't concede that.
Before
Get
I
him
guess
to defend
any more
what he's done.
surveys went out, if they're going to be changed. If the court will let us keep going with the way we're going, then we could make the comparisons from county to county. But if that's not what the court's going to do, I would like to see if there's a way to preserve what's been done
I don't like this.
by not looking at the questions that the court wouldn't want us to ask of other jurors. And I don't know if that works, so I need to talk to Dr. L.
Yeah, that's what I'm kind of interested in, trying to figure out when we have to start all over, how to approach this. And I mean, one of the things that I'm concerned about is how much this costs taxpayers money. And I have no idea. I'm not part of the money, part of this, but you know, if there's a way to kind of salvage something, I'm not happy about these specific questions, especially ones that are false. Then people hear that and they just get even worse sort of impression. Okay, Mr. COVID. There are also cases that are questions that are very specific that are going to be major issues in the trial. And so I'm really worried about that, particularly, again, I think this, I said disability, it's kind of ironic that you know, this with the time, the passage of time has kind of calmed down. You know, in terms of the media, very heavy initially. I have to say that to be here today, but the streaming has probably helped a little bit. Sort of kind of slowed things down intentionally, but I think people kind of move on a little bit, and then all of a sudden they get a phone call from a stranger talking about particular issues in KOHBERGER case, and so it kind of fires it up. And that's one of my worries. Also, just the fact that you can say 400 people, but 400 people in town spreads really thin. So it is dissemination. And I'm no expert about it. I don't know if I think you probably should. Mr. Edelman is going to hear this whole hearing, so maybe a discussion with him, maybe even a discussion with each other. Everything's kind of out in the open.
Sure
I'm
is.
very grateful. I'm very grateful for that because I like to kind of know to some degree what's happening in this case. And let's just deal with it really quickly. But I don't know, maybe we can next week.
Judge, I plan to be in town on the 11th. If the court wants a hearing, I can make myself available really any day next week. I already have plans for the 11th, but I can be available any other day the court wants.
So I'm going to be sitting with the Supreme Court in Nescos County. So could you maybe have a hearing, short hearing of some kind, maybe on April 10th? Or,
Your Honor, is that a Wednesday?
yeah, that's one.
I will if that's the only time the court has. Wednesdays, I have different things, but I can cancel them if that's the only time. If the court wants me to come back Monday,
I'll
I
work
can.
with you.
I could, 3 o'clock in the afternoon would be easiest for me on that day. On the 10th.
I have a treatment court meeting 2:30 to 3:30.
I can do 4 o'clock, or if the court wants to do it at 1, I can make that happen too.
Judge, I'm confused. What are we gonna have a hearing on?
Well, I want to see
Need to hear from the
what
expert.
thoughts you all have about dealing with the situation now, making sure that we can salvage anything or nothing. And Ms. Taylor's going to talk to Mr. Edelman, and maybe that'll give us some thoughts. Otherwise, I mean, I could just make the decision right now, but I'm no expert about surveys.
I
Yeah,
understand. Thank you.
you need to hear from the expert.
So I don't know how you feel about 4 o'clock on April 10. Could we just do that by Zoom, or do you want to be here?
Your Honor, Zoom would be fine with me. Mr. KOHBERGER would likely not be present. If he's present by Zoom, I will be here with him. So
Okay, I mean, well, we can do it in person.
let's go ahead and do it in person. I'll change my visiting day to Wednesday instead of Thursday.
Okay, is that okay, Mr. Thompson?
Yes, sir. We can be here 10th, 4 o'clock.
And, Ms. Masseth or Mr. Nye or Ms. Beatty can participate by Zoom. Thank you.
Yes, sir. Thank you.
Because I want to make the best decision I can, if that's possible. Okay, let's talk again about, having a hearing at least every month. It's just like cleaning up. And also, I guess you just did have a stipulation that you filed, but I have some, there it is. There's pending the state's motion to temporarily seal Exhibit 1 in the state's response to defendant's 12th supplemental request for discovery. Is that?
That would be, I believe, that would be covered by the stipulation that we filed today.
Yeah,
Okay,
the goal with that, Your Honor, is we often want to file those attachments to discovery under seal. Those contain things that shouldn't be made public. We both agree to it. And originally we were getting stipulations. And then I think we've done it so much, we just started doing orders. So the purpose of that is for us to just send along those and with an order for under seal, knowing that I'm always going to stipulate to attachments to discovery responses to be under seal, and the same with them. I mean, we know what we're each asking. So.
okay, and I agree about the perks too. Okay, so if you could just have a stipulation that says, with regard to discovery responses, you can go ahead and see. Okay, I mean, as long as it's justified.
And that's the intent of what we submitted today, Your Honor, is that attachments to discovery requests and discovery responses, not the cover document itself, but the attachments that have the details would just automatically be sealed when we're stipulating to that. So that would be routine.
Okay, great. So you backed off a little bit there, Taylor, Ms. Taylor, in that particular, you want everything, a hearing, or, everything needs to be stipulated.
That is a stipulation, Judge.
Well, it is, okay.
Oh, my Lord.
We also, Judge, I believe we have some other things on the motion to augment the record. We've been
Yes.
gathering more information on that, and it's my fault that I dropped the ball last month and didn't get a second batch of information compiled to Ms. Taylor. She got that today. We are contemplating that we will be able to present the court with a stipulation on that issue as well, with certain emails and communications attached to it, and then also have an ongoing stipulation about off-the-record communications, email or letter communications involving the court.
Excellent.
So we're making progress. We're working together on as much as we can.
There was a defendant's motion requesting additional deadlines that was filed on March 6th. We didn't ask for here.
Your Honor, I haven't asked for a hearing. I know the state filed an objection to that, and we don't have a hearing on that yet. My thought would be that after we submit everything on our motion for venue change, when the court's ready to make a decision on that, I think that's when we'd probably call for a hearing on our motion, and probably the state would want to be heard at the same time on their objection.
Okay, so that can just hang out there for a while.
I think so.
Okay.
That's what happens when you do no motions.
Then we got state's motion to unseal, state's motion for order of prohibiting contact with the prospective jurors absent leave of.
Which relates to what we've been talking about today, Judge.
Yes, I know.
We had filed our original motion under seal. The initial response from the defense was under seal that said we object. And then the defense's memorandum with the attached affidavit was not filed under seal. So our position was that, in fairness to the public record, that our motion should be unsealed and just keep the attachment sealed to protect the identity of the people who were interviewed by law enforcement or contacted law enforcement about being subject to the survey.
Any objections, Taylor?
In large part, no. There is a sentence in there where the state talks about evidence they plan to present, and that would seem like something they may want redacted before it became in the public record. Our response didn't have anything like that. I can show Mr. Thompson later, so in case he wants to prepare a redacted one for the board.
Do you know what she's talking about?
I don't, but we can talk about it, Judge, and Ms. Taylor just show us or send us what the language is. I'm sure we can work it out.
Okay, and so, and I guess this, we are already covered by the stipulation, defendant's motion to file exhibit M attached to defendant's 14 supplemental request for discovery?
That would be covered by today's stipulation.
Okay.
I'm getting the sense we're just kicking the can down the road on this survey stuff. And Judge is taking the opportunity to clean up his desk.
Okay, I think I've had my speech, so.
Thank you, Your Honor.
So we don't need to hear from Mr. Nye or Mr. Edelman at this point.
I don't believe so. I think that it may be more prudent for Ms. Taylor and Mr. Edelman to talk between themselves first. And I believe the due process issue that Mr. Nye was prepared to discuss has been resolved.
Okay, I have no doubt that I did not violate due process rights
Yes, sir.
of Mr. Kober.
Yes, sir. Thank you.
Okay, anything else, Ms. Taylor?
Not today, Your Honor. Thank you.
Okay, great. We are adjourned. Thank you all. Thanks for your patience.
Thank you, Your Honor.
Well, that was quite quite a little more energetic than maybe a lot of these hearings have been so far. Well, boy, I have some thoughts for sure. I mean, first off, to recap, just because I've seen a lot of people asking in the comments about what the questions are, it's very odd to me that the state is upset that these questions were posed to individual prospective jurors, while at the same time now you're going to put this on the public record in your court hearing where potentially thousands of people are going to hear about it. Have you heard, seen, or read? So just inquiries about very specific factual assertions that have appeared in the media, that he was arrested at his parents' home in Pennsylvania, that they found a knife sheath in the bed next to one of the victims, that the DNA found on the knife sheath belongs to Bryan Kohberger, that Bryan Kohberger owned the same type of car that was seen in the area that night, that the cell phone data places him in the area that night, that students lived in fear until Mr. Kohberger was arrested, that Mr. Kohberger said he was out driving alone on the night of the murders, that Bryan Kohberger stalked one of the victims, that Bryan Kohberger followed one or more of the victims on social media. And that went out to 400 residents of Latah County to basically get a sense of what is the penetration of this media coverage, and then based on that, what kind of effect is it having on the thought processes of the jurors? Now, I'm really frustrated that we didn't get to hear from the expert here, because all we have is Bill Thompson pounding the desk. This is inappropriate. This is inappropriate. This is inappropriate. Well, you're not the expert. You didn't even bring your own expert. You didn't even address the standards for how these types of things are supposed to be done, and you haven't looked at what is the purpose, what is the reason why you have to do this in the first place. Now, I understand perfectly well the state really likes to control how the defense does their job, because the harder you can make it for the defense, the more likely that things are going to go the state's way. And so when the state's proposing, oh well, it's just kind of like in voir dire, you just ask the jurors, well, can you be fair? I mean, come on, this is the worst possible voir dire that ever happens, because you don't get any kind of meaningful answer from that. Who really says, no, actually I can't be fair? It's something that has to be demonstrated based on what they know or think they know, and how they've processed and incorporated that into their views and their potential bias on the case. So it's very I don't like that we didn't hear from the expert, because to me that's a really critical part of being able to make the case for why this is necessary and why this wasn't appropriate. I mean, why this was not inappropriate. I really don't like I was screaming at the beginning of this hearing, to be Section 2B of the revised amended non-dissemination order from June says attorneys involved in the case and their agents may make extrajudicial statements, written or oral, concerning the following: information contained in the public record. That's what we're talking about. Bill Thompson is up here in this hearing saying, well, just because it's in the public record, that doesn't mean it's under some exception to the non-dissemination order. Yeah, actually it does. It very specifically does. That's actually literally what the order says. So the fact that that just kind of, I guess, got swept away and disregarded, I don't like that at all. I really wanted that to be hammered on, and we didn't hear anything about that. Clearly the judge came into this hearing with his own perspective already set on what he thought of this process that the defense was engaging in. And part of what, from my perspective, disturbs me about the process, like Ann Taylor is concerned about, is that that's kind of the anchoring effect that you get. It was set up by the way that it was presented for the court to have that type of reaction of alarmed. Oh, this is an emergency. Oh, this is something, really scary and concerning. Oh, this is something that's potentially in violation of the order. So once that's already set in his mind, you're already on the back foot trying to overcome that, particularly once an order's already been entered, because now he has to defend that order. We know perfectly well the judge is never going to say, oh yeah, I guess my order did violate due process. It's not going to happen. It's going to be a higher court every single time that always has to say that. Every judge is always going to say, I understand perfectly well what due process is, while they're violating your due process rights. So it's just kind of the nature of the job for a judge in that type of situation that, yeah, you're going to have to make those types of judgment calls. You might not always get it right. But to kind of get on the defensive and to be so closed to the possibility that there is a very good reason why these questions needed to be what they are. There's a very good argument that these questions are perfectly acceptable under the terms of the dissemination order as it's written. These are problems when the whole issue is presented in the way that it was here, where it just lands on his desk late in the afternoon. Big problem here, judge. You got to do something about it. That's now how it's anchored for him. So getting him to move off of that, I think, was always probably going to be an uphill battle. I just have a few notes here I'm kind of looking at. The judge, he's got this typical, I've commented on this before about how he's got, he wants to solve problems. He use that language here today. He just wants to solve the problem. And what he really means by that is he wants to get something that he can get both parties on the record to say, yeah, I'm okay with that, so that they can't go back and appeal it later on. Once you've signed off on the decision the judge has made, then you can't go back on appeal and say that was a problem, because you've invited that error. So that's really what's going on, and kind of the undercurrent of this approach that the judge takes with those things. He doesn't want the defense to be out there saying, no matter what, I think you violated due process when you entered this ex parte order. He doesn't want the defense out there saying, no matter what, I think we have the right to present the survey to get the factual basis that we need to evaluate whether this motion is going to be viable or not. There have always were going to be problems given this gag order. One of the problems with it originally, in my opinion, was it was just written in a way that was so vague, very unclear and unmanageable to figure out who does this apply to, what specific information does it apply to. And now the problem is it's kind of gone the other way, where they've nailed it down with so much specificity that now there's stuff in it that, it's potentially self-contradictory. So how do you know what applies? How do you reconcile, well, I can talk about information contained in the public record, but I can't talk about the identity or nature of evidence expected to be presented at trial or sentencing. If it's already in the public record, I'm going to assume I can rely on that part. But now, obviously, we have the state saying no. That's not the part of the order that governs. So really, anytime you're trying to limit the defense's ability to talk to anybody, and I mean, not just the defense. That's obviously just the context we're dealing with right now. But anytime you're going to try to limit their ability to do their own investigation, to potentially question witnesses, to potentially, get more information that could be pertinent to their case, you're going to have to talk to people. And in the course of talking to people, yeah, you might have to, one way or another, kind of share some information so that people know what you're talking about and know what you want, know what type of answer you're trying to get. So, I mean, to me, this really speaks a lot of volumes to why these orders can be such a terrible idea in the first place. I don't like them. These are public processes. They should generally be public. I understand very well, the issues that we've had in this case, the problems with just all of the nonsense that has been generated. I mean, the whole point of some of the outrage in this hearing today was that, well, this information is false. I mean, yeah, that's the point. And this gag order doesn't stop any of that. All it stops is people being able to correct the record. So yeah, continue to have problems with these types of orders in these cases. Boy, there was a question in the super chat I want to go ahead and come back to. Can you explain what a survey is meant to have in it? Well, so I have never done one of these surveys. I've never had a case that is this high profile that you would need something like this done in advance. Typically what happens when a high profile case is brought, most of the time you just deal with it at jury selection, and it's kind of understood that's part of the process of what you're going to have to question the jurors about. And so, yeah, you're going to have to be aware of what the media coverage was. You're going to have to be able to ask them about it. Now, what can you ask? How specific can you get? Well, that's where it really comes down a lot to the particular judge that you're dealing with, because some of them will give you broad leeway to ask about, you could set the stage. You could say on, such and such date, such and such publication, said this about the case. Do you have any recollection of that? Sometimes they'll take people out to do this in individual questioning, so you're not doing it in front of the entire panel. And that's generally a good idea, but that kind of mimics what's going on in this sort of telephone survey, where it's just a one-on-one, and you're not publicizing this whole thing to the world, at least until the state gets a bee in its bonnet and has a whole public hearing about it. So some judges will give you a lot of leeway to do that. Some of them are going to say, no, you can't litigate the facts. And yeah, it's really frustrating as a defense attorney to deal with judges who just simply refuse to allow you the tools that you need to be able to make your record. Very, very, very frustrating. So, I mean, to try to answer this question, I wish the expert had told us. I wish that they had called him so that we knew what the survey is supposed to have in it, because according to him, there's very specific standards for this type of thing. And we have to assume that, from what he's told us, his survey comports with these standards. So really would have been helpful to hear a lot more about why that is, how these surveys are supposed to work, why they need to be structured the way that they are. And it sounds like, maybe we will or will not hear from him next week. But I just really don't like that judgment call from Ann Taylor. I understand she's got to make those types of decisions on the fly about how to proceed with the hearing. But I really wanted that record. I really wanted it, especially for appeal. So let's see what else we got here. I'm getting the hang of this live thing. I think I want to thank everybody who's joined in on the super chats, and thank you to Uncivil and to Ian Runkle and to the Chungi Show. You guys for welcoming Aussie Insider. Yeah, all of you folks that have shown up to support. I really appreciate it. these surveys not standard practice? I mean, no, because they cost money. I mean, that's the bottom line. You heard what the judge was saying. My concern here is about the cost. Well, yeah, because experts and stuff like this, to do it ahead of trial, to do it in a way that's not going to potentially taint the jury panel, yeah, you're going to have to pay somebody money to do that. And so in most cases where you don't have the death penalty on the table, where you maybe don't have this type of profile that this case has, you're not going to get approval for that funding. They're going to say, just deal with it in voir dire. And so that's typically, at least in my experience, what's going to happen. Thank you. I'm learning. So appreciate your support. Oh boy, I think the last thing I kind of want to close on with just my sort of general comments about all of this is that it's really, I feel like a lot of you guys are maybe starting to share my perspective on what it's like to be in a small town with a small town practice, because you really start to see the relationships and how those kinds of things can play out in ways that you hope that they wouldn't, but it's just always going to be there with people that the court is used to dealing with over and over and over again, as opposed to courts that are extremely high volume and high traffic and lots of people in and out. You may or may not see the same lawyers all that often. And so my impression, I've definitely had the impression from being, when I've been present in the courthouse, that this is the type of county where they really like to get along. And we kind of see that from Judge's demeanor and the way he handles things on the bench. He likes the stipulations. He wants the parties to be able to work well together. You know, that's not going to happen all the time. I mean, it's honestly kind of shocking how well they've worked together so far, how many things they have been able to resolve by stipulation. But this is a death penalty case and an adversarial system. They are absolutely not going to agree on everything. And the judge is going to have to make those calls, knowing that somebody is going to be unhappy about them. And if that somebody is the defense, then yeah, they may appeal it. That's just part of the hat you wear when you become a judge. And so you can't, it's not good to take that stuff personally. It's the process. But I noticed it particularly with just the way that, like, the bailiffs, for example, would interact with the press, and just with everybody. I mean, don't get me wrong, I love the bailiffs. The bailiffs are awesome. They're super nice. They're very friendly. They're kind of hilarious sometimes. I like bailiffs in general. They just tend to be kind of good people. But my just overall impression is that nobody has really wanted to, like, lay down the law when it comes to saying and just enforcing, here's what's going to be acceptable, here's what's not going to be acceptable. There's just kind of this sense of, well, we want to be liked, we want everybody to get along. And so I think you kind of see that as well, you know, starting to carry over into this court proceeding, that the judge doesn't like being accused of making a wrong decision. The judge doesn't like being kind of left out of the process of what the defense is doing. But this is normal. You don't have to ask permission to do your job as a defense attorney. You don't have to tell the prosecutor or the court what you're doing. That is your work product. That is something you're entitled to keep to yourself. So just where this expectation, I think, would even come from is a little bit baffling to me. And it is kind of concerning to me that it's really taken for granted that you know, that the state and the court should even have some say in this process, and some role in deciding what kinds of questions should be asked. I mean, go ask your own questions, go do your own survey, go hire your own expert to tell us why this is a problem, instead of just pounding on the table because your knee-jerk reaction to it is, I don't like that the potential jurors are being asked this question. So No question, really, that were there not a gag order in place, there would be no reason to go to the court at all, other than to get approval for costs to do this kind of work. So that really is just, it's what it keeps coming down to, is what's really throwing a wrench in this process, is this desire to control what we know and what we don't know, what we're allowed to think about and hear about. And just this idea that all this stuff is already out there that's false, and all we can do with it is just put our heads in the sand and pretend it doesn't exist, pretend it doesn't have any effect on anybody that did hear it. To me, that's just completely unrealistic, and it's unfair. It's preventing Brian Kohberger from being able to raise issues that have a legitimate chance of affecting his right to a fair trial. So I'm just going to check and see. I think I saw another super chat come in from Duty Ron. Hey, Ron. Oh, it's so good to see him. I've been on Ron's channel in the past. He's one of the good ones. Really appreciate him. So yeah, boy, guys, I guess we'll be back next week, but I'm going to go ahead and wrap this up now. So, hey, I think it kind of went all right. Thanks so much for joining me. And yeah, this was fun, and we'll do it again. So stay tuned, and we'll see you next time.